Greetings, ladies and gentlemen. Welcome to your Law in the Streets channel, your only law room channel that brings legal content on specific topics insofar as board exams are concerned. Ladies and gentlemen, today we'll be looking at the topic which you find frustrating, and that topic is estate duty addendum insofar as it has to do with the whole liquidation and distribution account in your wills and estates paper. Today, ladies and gentlemen, we will only be focusing on that estate duty addendum alone and showing you what are the rules pertaining to some of the entries that you have to do in the estate duty addendum. As you can see from my screen, there are two sides of the table. There is column A, there is column B. And on column A, there is deceased that is married in commit of property, and in column B, there is a deceased that is married out of commit of property, and that includes with or without accrual. Under column A, the way I'll be making a presentation, I will look at column A and look at the same thing under column B, so that everything is summed up in one explanation. As you know, the estate duty, ladies and gentlemen, it has certain headings. So here I will start with the first heading. The first heading is property of the deceased. This is the property that is of the deceased. It's not property deemed to be property. Under paragraph 1 and 1.1, what you will do is that you will record the total assets from the liquidation and distribution account. I don't know how you draw your L&D. Some people, when they are on estate duty, they do a column for recording, two columns for recording amounts, whereby if something is a credit on the deceased, it's not a deduction, they put it on the credit side. If something is a debit, they put it on the debit side. But because people draw these accounts differently, I will simply just explain what to do with each. How you draw it, it's up to you. Under 1.1, you record total assets from the liquidation and distribution account. Take note, these are the total assets from the liquidation and distribution account. In column A, you do the same. In column B, if the deceased is married out of commit of property, you still do the same. Then, you will then have things such as shares. How do you deal with shares? You must know that there are shares that are in a private company and there are shares that are in a public company. Shares that are in a public company do not have or are not supposed to appear here. Only shares that are in a private company. You know, your question sometimes will put a scenario and for shares that are in a public company and shares that are in a private company. So here we only deal with shares that are in a private company. As you have seen in our previous video, I've dealt with the mistakes that people do on 5 tips in wills and estates. So here, shares, only those in a PTY Ltd, private company. If sold for less than the valuation, you add the difference between the valuation and the selling price. The same thing happens in column B if you are dealing with an estate duty addendum for a person who's married out of commit of property. If shares are sold for less how? If they were sold less than their valuation, you add the difference between the valuation and the selling price. If they were sold more than their valuation, you deduct the difference between the valuation and the selling price. The other thing that you deal with is the farm. If they say there is a farm that is used for bona fide farming, that farm you have to deduct 30% of the sold value of the farm. If the farm is for 5 million, you have to deduct 30% of that 5 million. The same thing you do also under column B if the deceased is married out of commit of property. So here there is not really a difference between the one who's married in commit of property and the one who's married out of commit of property. Then we go to the following entry. On the other entry, you will see that you now have to deduct life policies that are on the life of the deceased and are payable to the estate. The same thing that you do on the column A, when the deceased is married in common of property, you also do when the deceased is married out of common of property. Then now we see the difference between the two columns. Under column A, you will then deduct half in terms of the matrimonial property regime because it's married in common of property. And then on the other side, you will deduct any claim in favor of the estate for accrual. So any claim in favor of the estate, not against the estate, because a claim that is against the estate will be dealt with as a liability against the estate. But here you deduct any claim that is in favor of the estate. And then the second thing again on married in common of property is that you will add any limited right that the deceased enjoyed when they were still alive. For example, if they had an usufruct, if they had fideikommissum, if you know those limited rights that the deceased had, there is a formula on how to calculate this, and I'm sure if you are dealing with estate duty in detail, the notes will address how to deal with that formula insofar as X factor is concerned. And also on the side of column B, you do the same thing. You will add any limited right that the deceased enjoyed at the time of their death. There is a formula that you see on column B on how to calculate this right. Sometimes they give it to you on the question paper because it's too much of time to calculate this. Now the second heading of your estate duty addendum is that of property deemed to be property of the deceased. Here what do you do? And I must point out, ladies and gentlemen, that as you are descending with your calculations, you must always, after making every deduction, put the subtotal so that you are not confused. You deduct from the last subtotal that you just had. You don't deduct up there because you no longer have that same total. Under property deemed to be property of the deceased, what you do is you add all life insurance policies that paid out on the death of the deceased, even policies that are payable to beneficiaries. But here you don't add policies that are payable to a spouse or a child in terms of an antenuptial contract. The question will state that this policy was payable to the son of the deceased in terms of an antenuptial contract. Then you must know that in the estate duty addendum, that policy will not be taken as property deemed to be property because it's a policy that must not be added under those kind of policies. So you will add all life insurance policies that paid out as a result of the deceased death. And if there are I don't know, some people call them kind of policies, but they are called keyman policies. They may be excluded if section 3 paragraph A applies of the Estate Duty Act. And on the column B also, you see that you do the same thing, the same rules shall apply. You add again payments, but not those that are voluntary or ex gratia payments, in terms of pension funds and retirement annuities. But here, you must apply section 3, subsection 3A bis for calculations and exceptions. You will look at that section of Estate Duty Act. The same thing that you do on column A, you also do on column B. Then the other thing is that normally they don't bring questions that have to do with pensions, funds, and retirement. The second thing that you will do is to add the difference between consideration paid or given to the deceased in a family company or normal value of shares, and only if the consideration exceeds the value as enshrined in section 3, subsection 3CB. The same thing that you do on column A, you also do on column B. Now, on column B, as you will see, you will then add any claim in favor of the estate for accrual. So if the deceased had a claim against the surviving spouse, you will add that as property deemed to be property. You will add that in favor as a claim in favor of the estate for accrual. Then you will have a subtotal of gross dutiable estate, and then now you will come to number 3, heading number 3 for allowable deductions. Allowable deductions, if the person is married in common of property, that will be deductions, deduct total funeral cost and deathbed expenses except unnecessary luxuries, just like flowers, food, in terms of section 4A. And the Commissioner of SARS will not just allow certain costs that are escalated for cards and all that in terms of which a person was buried. And then you will also deduct half of the claims against the estate, because here the people are married in common of property. You will also deduct half of administrative expenses. That is in column A. And then column B, allowable deductions, you will deduct total funeral cost, that bear the expenses including tombstone, but not unnecessary luxuries. And then you will, section 4A, the total claims against the estate and the total administration expenses and the administration expenses incurred in terms of Estate Duty Act. Those will be deducted. But if the person is just married out of common of property, you can just simply deduct liabilities overall as a whole. Even on the other side, on column A, you can simply just deduct the total liabilities if you are satisfied that they include all the things that have to be deducted, and divide them by 2, because time is not there to set out each one of them separately. The other deductions that you will do is if there are foreign assets situated in another country and deceased became the owner of those assets before they became a resident of South Africa, or it was a gift or inheritance, you will deduct same. You will also deduct any bequeathments and benefits. That includes inheritance, policies that pay to the surviving spouse, but not her transfer of half of the estate. So you will deduct those things that are paying to the surviving spouse. And the same thing here on foreign assets happens on column B. Here on column B, you will then deduct bequeathments, benefits that pays to the surviving spouse, and the same rule will apply, but not their share of accrual to the surviving spouse. And then you will also deduct any bequeathments to a charitable or educational institution of South Africa of public nature and that promotes science or art to a local government or the state. The same thing you will do in column B. You will see that some questions will tell you that in his will he said this much must be donated to this institution. And then you must note that certain rebates will be allowed on the calculation of value of an usufructuary or fideikommissary property. The same rule will apply in column B. Then you will come on the subtotal of the net dutiable estate after doing all these deductions provided on your questions they apply. You will then less the primary rebate in terms of section 4 capital letter A of Estate Duty Act, and that is 3.5 million if the deceased passed away after 1 March 2007. And then on that you will calculate estate duty payable at 20% if the deceased passed away on or after 1 October 2001, but at 25% for estates before 1 October 2001. Then you will do the same thing that happens on column A also happens in column B. Then what you will do, again, you will do the allocation of who has to contribute towards the payment of estate duty. Any person who received a limited right or insurance policy as a beneficiary should contribute at the following formula. You will deal with it as follows. Value received less possible deductions divided by net dutiable estate and the amount of estate duty payable. Then the estate will be liable for the difference. On the same side again on column B, it's the same formula that applies. You know that some estates there will be no cash to pay for the estate duty, but you are going to make the beneficiaries contribute in terms of this formula. With that being said, ladies and gentlemen, I must say these are some of the things that need to be studied insofar as estate duty is concerned, so that the person knows what needs to be deducted, what needs to be added. Reason being, you cannot deduct things that you don't know what they are called in estate duty, and that is one reason that makes many people to think estate duty is boring, because they don't even know what is contained under estate duty. I hope I have tried to set out the things that need to be included in estate duty, and also if you have been at a law school, you will see that in a manual for law school there are discussions about each item of estate duty, on how to deal with estate duty and what each item is for, insofar as it is an entry that has to be made inside estate duty. For example, some people confuse accrual as a claim against the estate and accrual as a claim in favor of the estate. In the estate duty, we only deal with the one that is in favor of the estate. We don't deal with the one that is a claim against the estate, because that is a liability which we already dealt with in the liabilities section. I hope with this discussion some people will have an idea of what really is estate duty.